Item 8C, there was a request to defer the item to November 19th, but a couple of people have shown up to speak for a non-deferral. Debbie Blackburn? Okay.
Mayor, could I possibly set the stage for this a little bit, and then I'd like to hear from everybody. How are you today? I'm glad to see you here.
Good. How you all?
Great. This is a very complicated situation on the address of the property is 121 Northwest 22nd Street. It's in Heritage Hills East. It's a historic neighborhood. This house has been dilapidated for a very long time and is very concerning to the neighbors, and I know that's what we're going to hear today. The situation with the property is that it's currently in litigation. The house was acquired for past due taxes some time ago, and ownership is somewhat in dispute. We've been working through the process, and Charles and his group have done a fabulous job. I think this really is an example of something that kind of falls into the category of what we're working on with vacant and dilapidated houses. But we did get a request yesterday from legal counsel for the owner to defer this for 30 days. And I think it's important for me to say on the record that these neighbors I know are particularly concerned, live next door, have been working on this. Debbie's been working on this for years. But there are also folks in and around the neighborhood that aren't quite as enthusiastic about seeing this property taken down. And my decision to allow a 30-day deferral would be to give one more opportunity, number one, to clear up the ownership issue, because the gentleman that bought the tax title to the property, I think, would like to restore the house. And secondly, it provides one last opportunity for someone in the neighborhood that might consider purchasing it and restoring it. So, our HP Commission isn't at all concerned about the shed, which is an ancillary structure, but they do comment, rightfully, that the structure properly restored is a contributing structure within the neighborhood. So I'm just trying to buy a little bit of time here, and that was the reason for the deferral request. So,
Mayor, if I could add a couple of things.
Yeah, sure.
One is, it was represented to me yesterday that they thought they could get the title cleared within 30 days. I don't know if they can do that or not, but that was what was represented to me yesterday. And I do want to pass on Councilman Salyer's comments from yesterday, where maybe 30, but it isn't going to go 60. So she was showing a little bit of deference to try to get the title resolved, but it was very clear that this was not going to be allowed in more of a continual basis. Was that accurate?
I don't do it. Oh, that guy had 12 years. I mean, I've been gone 12 years. My name is Maurice Taylor, and I live next door for like 15 years. And I have a tenant in there with some small children, and the house is so open and dilapidated, the rats are coming into my basement. So it's been a tremendous economic situation for me. I can't do anything. I can't sell, and I can't rent. I can't rent the house. So they've had a long time to get that together. If I can get it together, I feel like they can get it together. I'm just up to my neck now. I own over 30 properties in Oklahoma City. I am a doer, and I'm a worker. My rent houses look better than that.
I know that, and I really...
Yeah, I'm just up to my neck. At first, I had consideration, but now I just let it go too long. It's awful. It is awful. I just disagree with giving him any more time. Thank you all.
All right. Thanks for coming down. Debbie, do you want to say anything?
Yes, I do.
Okay.
My question is, what are we going to do in 30 days deferral? What is the point? This battle over who owns the property, the idea that anybody could rehabilitate this when I can walk up to the site and look in through the siding into the house, it's ridiculous. This house is not habitable. The Department of Health has put notices all over it. It's not habitable. They were in court 2 weeks ago The plaintiff did not show up. The counselor who asked, his attorney who asked for this deferral did not show up. And by default, the property went to the person who has paid the taxes on them. Councilwoman, I hate to disagree, but I can find, there is no one on that block that believes that house is salvageable or wants it to stand or to remain. It is an attraction for vagrants. My problem was that because this man was my neighbor for many years, I didn't do anything because he was on a downward slide. And this is what we ended up with. My question is, what are 30 days deferral going to do? This battle over who has ownership could go on forever. They didn't even bother to show up 2 weeks ago in court to fight for this property, and now they want a deferral because they know that they can get one from the council, having had association with the council. This house is not, and I say this, my husband is the State Historic Preservation Officer. We fight in this neighborhood to keep every single house standing. So you know that if I'm here today talking about that it's far gone, because normally I am on the other side every time. We have mosquitoes, we have rats. This guy is a hoarder. He's putting stuff in the backyard now again. He's putting stuff on the porch again. I can walk up to the side and I can look in. My question is this. You may go ahead and defer to your former colleague because he requested this. But what is 30 more days going to do? Can he get title to this when he wasn't in court 2 weeks ago? Judge Dixon already defaulted on and gave it to the person who's paid the back taxes on it. When, you know, I always thought that my rights end where yours begin and vice versa. This guy is standing on my feet. He's in my face, and I am tired of it. We have property I would like to sell it. I would like to get it in shape, put money into it, and sell it to homeowners. It's not safe to do that. It's not safe to do that with this. And until this is resolved, and it's always been, well, it's in court. Nobody knows who owns it. We can't do anything about it. That is not good enough. If that's torn down, the lots in that neighborhood, because of the proximity to downtown, are selling for $50,000 just for the lot. So there's money that could be made. If he doesn't have title to it, how's he going to get it in 30 days? There's no reason to defer this unless we just want to be nice to a colleague. I hope that you remember this. If you do vote to defer it, that when it comes up again in November, that you do something about this. This is a travesty.
Debbie, could I just, a couple of things. One is I didn't suggest it was somebody on the street that was concerned about the house coming down. It's other folks in the neighborhood, which is important. And I also want to say that you and I did talk about this on more than one occasion, and the legal cloud over who owns that property makes it difficult to take it down. And within 30 days, we will know who owns that property. Mr. Chen, who you just said gained right to the property by default, is the one that said he wanted to fix it. He's one of the individuals that says he wants to try to restore the house. He hasn't been by there in a long time. Okay. He's not going to be able to. He'll have to build it from the ground up. And that's a possibility. So this thing has been going on for, as you all said, probably 15 years. I've been directly involved with it with you for the last year. I'm completely on board with taking it down after 30 days. Well, the thing is, they've gone to court over and over and over and over and over for years, and it hasn't been resolved. Ownership has not been resolved. And this has been the excuse that the city has used for not taking it down. Now, I pledge to you today that this is the last deferral. I want to give them time to clear up the title, and after that, it's already been declared dilapidated. We can take it down. How are we assured that we're going to get title, Councilwoman? Well, either we have it or we don't. but it's been declared dilapidated.
So
We're
in 30
prepared to
days,
go forward.
regardless of what happens
Yes.
on ownership, you will go ahead?
Yes,
And why can't we do that today?
because we've had a request to hold it in abeyance for 30 days.
Okay.
I'd make a motion to defer.
Have we already deferred it, or we need to make a motion? No, we need a motion. We have a motion. Do we have a second?
I'll second it, but I do have some questions.
Okay.
Procedurally, Charles, if we did not defer this and voted to move forward with tearing this down, how long, when could you begin?
Well, that's always a iffy question, but probably the soonest that ever happens is about 45 to 60 days. And that's simply because of the permits that are required for our contractors after they've successfully bid the project to obtain those permits, get the disconnects and whatever they need to proceed before we can grant them permission to take down the property.
Well, okay, well, let's play this out then. If we agreed to vote to allow this to be considered dilapidated and move forward, if something happened within those 30 to 45 days, you could put a stop to that procedure, couldn't you?
We can stop it up until the time the bulldozer gets on the property, yes.
Okay.
And the owner also has an opportunity to go to district court and file a restraining order against us to grant him any additional time also. So that's always open to the owner.
Well, given the uncertainty as to who owns the title, I would anticipate that's going to happen. So even though even though I second the motion, I'm leaning towards voting not to defer this. Thank you.
All right. Well, we have a motion to defer. Is there any other comments or questions? Yeah, Larry?
Yeah, I got a question, Charles. Why is this any different than the one that was here earlier, where we gave the gentleman, we said that we're going to leave it on the docket, and if you show progress, we'll work with you. Why is this any different? Why don't we just leave it on the docket, and if they work it out in 30 days, that's one thing. If they don't, we've at least, I think, sent a message, hey, we're serious about this.
It's no different procedurally at all. It's just that the only thing that makes this different is our HP commission has put comments that this is, this house does retain historic value, and that's their opinion. Our opinion is we brought it. We do not think it retains its historic value because of the condition of the property. That's why it's here. That's why we recommended it to go on the docket. But procedurally, there's no difference. The owner would have the same opportunity to file a TRO if we proceeded and they disagreed with us to take it to court, just like any other owner would.
Well, not to disagree with my good staff person, but the difference is that there is clear title on one, not clear title on the other. And so that if there isn't clear title, then someone can't step forth with the direction and a plan to go forward with it without the clear title, whereas on the other property, they do have clear title, so if they've got a plan, they can execute that plan. And I'm not here to, it's a policy decision, but that's how I would differentiate the difference between the two, outside of the fact that one's HP and one's not.
Do we officially notify the owners that we're moving forward if this were to be voted to move into a dilapidated status?
Yes, we would notify all the owners that we're aware of, plus any mortgages or any person that has interest in the property.
Kenny has said that he would have to notify both owners and the district court that we were planning to do this.
Okay.
So, quick question. So, the district court, if we voted to go ahead and tear it down, so the district court, if one of the owners filed a motion with the district court can halt the procedure, right?
Yes, that's a possibility. They could. Our experience, however, with owners going to district court to try to keep us from tearing down what are obvious dilapidated buildings is that the court will give them a very short time period to get something done. So that might buy them a little bit more time, but it usually doesn't buy them more than 60 days.
You have to come up to the front, Debbie.
would like to remind the council that this is not something that's just been going on for the last year or the last 2 years. This has been a 25-year downward slide. And initially, because of the property owner, and we cut him a lot more slack than we should have. We didn't want to lose the house. We let it go too far. And so this is not something, Councilman McAtee, that, has been something that they were given ample opportunities. He's paid thousands of dollars in fines. Code enforcement tried, and he's paid thousands in fines. And he would go over and show that he was going to work on the house, so what would he do? He would get out and scrape the paint off. And that was to show the code enforcement that he was starting on it, he was doing something. This has been a long, painful odyssey, and we do not take old houses down easily.
All right, we have a motion and a second to defer this item to November 19th. Any other comments or questions from council? All right, we ready?
I have one question. I'm not sure there is a cloud on the title. I mean, they've been to court. The judge ruled in favor of the taxpayer, the tax deed purchaser. Now, there is an appeal period from that still runs, but that judgment is there. It says who owns the property. It seems to me that if in the 30-day period, the guy, the deed holder, the guy that has the property based on the deeds, would file an appeal or file a motion to reconsider the order then there would be a dispute. But at this point in time, there isn't a dispute, it seems to me. I mean, I shouldn't be playing.
I haven't looked at the
I have a lawyer.
I haven't looked at the OSCN record to see what's actually in there, but Ms. Blackburn said that the default judgment was granted in favor of the person who had the tax deed. So right now, there would be a default judgment in favor of the person who acquired the property pursuant to the tax deed. And the other guy, if he wants to contest that, is either going to have to file an appeal or he'll have to file a motion in district court to get the judge to set aside the default judgment. If the default judgment is set aside, then you'd be back in court on who actually owns the property.
And that would stop us, because we wouldn't start for 30 days. If that default judgment was rendered 2 weeks ago, he's got 30 days, I believe that's the rule, to file an application for a rehearing or to a motion to set aside. So that would have to occur within 30 days from now. And if he did that, then he'd have his own. Then we would be back really locked into a situation where we didn't know who owned it, and we would have a serious problem. But as I understand it, we could actually tear the building down, whether there's a dispute about title or not. The question is not whether there's a dispute about title. The question is whether or not the house is dilapidated.
Yeah, the only way the dispute about title plays into it is who has the authority to go on the property to fix it up. That's, I mean, right. As far as us tearing it down, as long as we give notice and opportunity to be heard to anyone who has an interest in the property,
which we've done,
we can declare it dilapidated and tear it down unless the district court stops us from tearing it down.
I guess the only comment I'd like to make further is that the person that now has title, based on the decision of the judge 2 weeks ago, is the person that would like to try to restore it. So,
but if we keep it on the list, he's got 30 days to do something about it.
That's true.
All right, ready to vote?
Your Honor,
the vote is to defer. Right. Right, ready to vote. All right, cast your votes. And then vote for the deferral fails. It is 3-5. Okay, 3-6.
Can't be 3-5.
So it's on you left it on the list as declared dilapidated, so they still have 30 days to take some action before we'd be out there tearing it down.
All right. On to item D, this is a public hearing regarding unsecured